Hi y'all, thanks for popping by. If you would like to crochet along with me, you can find this pattern for the bamboo fence on my crochet playlist, or just hang out for the story. Either way, I'm glad you're here.
Ralph Menzies' 37-year death row sentence reflects prolonged legal battles, competency evaluations, and evolving capital punishment laws. Convicted in 1988 for the kidnapping and murder of 26-year-old Maureen Hunsaker, his case has been a torturous judicial journey, recently including a competency hearing focused on his alleged vascular dementia. Delays arise from appeals, standard in capital cases, and arguments that his dementia renders him unfit for execution. Extensive evaluations assessed his understanding of his situation and sentence, complicated by shifting legal precedents on executing the cognitively impaired. While some suspect strategic delays, others cite his genuine cognitive decline, preventing him from comprehending the consequences of his actions. A pre-execution competency hearing showed the devastating effects of Menzies' dementia. Neurological evidence showing significant brain damage corroborated expert testimony detailing profound cognitive impairment. Experts concluded he cannot understand the link between his crime and the death penalty, his inability to perform simple tasks exemplifies his decline. The prosecution, however, claims this is a manipulative tactic. The judge now weighs conflicting evidence, facing an ethically and legally momentous decision regarding Menzies' execution. Stated on May 7, 2025, the judge said he would issue a written ruling on Menzies' mental competency within the next 60 days, which could include another hearing.
Right, so imagine this for a second. It's quite a stark image. A man on death row, his lawyers claiming his mind is slipping into dementia, facing execution not by lethal injection, but by firing squad.
Yeah, it's incredibly striking, isn't it? And it's happening right now in the U.S. in the 21st century. It immediately puts a spotlight on Utah and specifically the case of Ralph Menzies.
Exactly. And for us, thinking about this, it really boils down to two powerful questions that are guiding this deep dive. First, about Menzies himself, the legal and, human question. Does he know what's happening?
Does he really understand why the state might take his life?
Yeah.
That's the core of it.
Right. And second, looking at the method itself, why firing squad? Why is this method, which feels like it's from another era, still even part of the conversation in Utah?
Well, we've pulled together a pretty fascinating stack of sources to try and wrestle with these questions. We've got recent news reports giving us the latest on the legal battle over Menzies' mental competency.
Oh.
And we're pairing those with historical accounts and even some religious texts that really dig into Utah's unique past with capital punishment, especially, the use of the firing squad.
So our mission for you, the listener, is to kind of guide you through this really complex landscape where, legal standards, deep history, and even these religious echoes all sort of collide.
Yeah, we want to help you understand why this particular case, with these specific questions around competence and the method of execution, is so significant right now.
Okay, let's unpack this then. So let's start with the man right at the center of this legal storm. Ralph Leroy Menzies. The sources tell us he was convicted way back in 1988. It was for a truly horrific crime, the 1986 murder of Maureen Hunsaker.
Right. She was abducted from a gas station and later found, well, the details are brutal, strangled and her throat cut.
And he's been on death row ever since that conviction. I mean, for a very long time.
Yeah, the sources say 28 years, maybe even more, decades.
And that incredible length of time brings us right up to the present day and this legal challenge. There's a competency hearing that's either underway or just happened recently.
That's right. Sources mention hearings, specifically pointing to one that started in November 2024. The whole point is to determine if Menzies, who's 65 or 67 now?
Somewhere in that range, yeah.
Is mentally fit enough to actually be executed.
And the core of the defense argument, it seems, is that he's developed dementia.
Exactly. Their claim is that he's now so mentally impaired that he simply cannot rationally understand why the state is planning to execute him. It's not just about, forgetting things.
No, it's about the connection.
It's about grasping that fundamental link between the crime he committed all those years ago and the punishment he's facing now.
And his attorneys are apparently using some pretty specific examples in court, things that really try to illustrate this impairment.
Yeah, the sources mention things like him forgetting to renew his necessary medications, or being unable to do his own laundry because he's actually forgotten how a wash machine works, and even using a tablet computer like a toddler would, things like that.
So this isn't just a minor memory slip argument.
No, they're painting a picture of significant cognitive decline, and this ties directly into the legal standard here.
Right, because the Supreme Court has weighed in on this.
Yes, they have.
Yeah.
The court ruled that executing someone with severe mental illness or diminished capacity, maybe from brain damage or a stroke, or in this case dementia, is unconstitutional if they lack a rational understanding of the reasons for their execution.
A rational understanding. That's the key phrase.
That's the legal test. It's about whether they can truly connect their past actions to their present fate in a meaningful way.
Okay. But like in many legal battles, it's not straightforward. There are opposing views being presented in court, right?
Absolutely. The sources tell us the prosecution has its own medical experts, and they're testifying that, in their opinion, Menzies is competent.
So directly contradicting the defense experts.
Yeah, exactly. It's a classic battle of the experts, a really profound medical and legal conflict that the judge has to sort through.
And we know who the judge is.
Yes, Judge Matthew Bates is overseeing this hearing. And our sources say he's expected to make his ruling on Menzies' competency within about 60 days of that November 2024 hearing finishing up.
So a decision could be relatively imminent.
Could be. And just to add another layer of legal complexity, the sources also mentioned the judge was considering whether to disqualify the state attorneys involved
Why is that?
over alleged improper communication between different state agencies working on the case. It just shows how many procedural tangles can arise in these situations.
It really does. Now, what about the victim's family? Their perspective must be incredibly important here.
It is. The sources mentioned Matt Hunsaker, Marine's son. He stated that he believes Menzies deserves to be executed.
Understandable, given the crime.
Yes. And while he seems to respect the legal process, his feeling is that a finding of incompetence shouldn't automatically spare Menzies. Though interestingly, the sources do note the family might reconsider their push for execution if he is found incompetent.
That adds another human dimension. So the immediate stakes here are incredibly high.
Absolutely huge. If the judge rules him incompetent, Menzies likely stays in prison for life. But if he's found competent,
then execution by firing squad could actually happen relatively soon, maybe in the spring?
That seems to be the potential timeline, yeah.
Yeah.
Assuming, of course, there aren't further appeals or maybe a clemency hearing doesn't change things.
Which brings us inevitably to the other really big question hanging over this entire case.
The method itself, the firing squad.
Yeah, it's definitely not the standard way executions happen in the U.S. anymore. But Utah, it's different.
It is. Utah has this unique history of actually using it in relatively recent times. The sources list several individuals executed this way.
Like Gary Gilmore back in '77. That was a really famous case.
Hugely famous. And then John Albert Taylor in 1996, and Ronnie Lee Gardner more recently in 2010. So it's part of the state's modern history with capital punishment, not just some relic.
Okay, so why? Why does Utah have this connection to the firing squad? Where does that come from?
Well, according to our sources, the history behind the legality of the firing squad in Utah is deeply intertwined with the state's past. Specifically, laws allowing it, and apparently at one point even decapitation in the Utah Territory and then the state, were reportedly influenced by a historical doctrine from early Mormonism.
Religious doctrine.
Yes, something known as blood atonement.
Blood atonement, that sounds, well, intense. What exactly was that concept based on the sources?
The sources describe it as a belief held by some early leaders and members that for certain really serious sins, things may be considered beyond the reach of Christ's atonement, like murder, or what they called eternal sins, maybe even adultery or apostasy in some interpretations. The only way to potentially achieve forgiveness or avoid the worst eternal consequences was for the sinner's own blood to be shed, literally spilled upon the ground.
Wow. So the idea was a kind of sacrifice of one's own blood.
Sort of, yeah. A sacrifice necessary, potentially, to prevent becoming what they termed a son of perdition or losing out on eternal exaltation, a very specific spiritual weight attached to the manner of death.
And Joseph Smith, the founder of Mormonism, his views are mentioned.
Yes, sources say he reportedly favored execution methods that involved shedding blood, shooting, or decapitation overhanging. He apparently saw those methods as aligning with the principle of blood for blood according to the law of heaven.
And Brigham Young, his successor.
He seems to have been a key figure in teaching this doctrine, especially during a period in the 1850s called the Mormon Reformation. Our sources mention some of his more controversial statements about it, including ideas about even voluntary blood atonement in cases like adultery under very specific and frankly quite extreme conditions.
This is pretty heavy stuff. But what's the official stance today? from the main LDS Church.
That's absolutely critical to clarify. The sources are very clear on this. The Church of Jesus Christ of Latter-day Saints, the main LDS Church, formally repudiated the practice and concept of blood atonement way back in 1889.
Okay, so over a century ago.
Yes, and they've strongly disavowed it multiple times since then. It's not some hidden thing. They've been very public about it.
So how do they explain those earlier teachings?
Well, quotes from later church leaders, people like Bruce R. McConkie and Joseph Fielding Smith, and entries in things like the Encyclopedia of Mormonism, they explain it this way. While there might have been some theoretical discussions about certain sins requiring such an atonement in, say, an ancient theocracy like the time of Moses.
Right, like a historical context.
Exactly. But they state emphatically it is not a doctrine of the church today, it was never practiced by the church institutionally, and it absolutely does not apply to anyone living now.
They really draw a clear line.
A very clear line. The sources stress that according to current LDS church teachings, the shedding of a sinner's blood is not necessary for the remission of sins today. Christ's atonement covers that.
Okay, that's a crucial distinction. But despite that very clear official rejection, did the idea linger somehow?
It seems the historical influence may have had some lasting resonance, yeah. The sources mention that, remarkably, potential jurors in Utah death penalty cases were still being asked about their beliefs on blood atonement during jury selection, at least up until 1994.
Wow, that recently.
Yeah. And there are also reports that some fundamentalist splinter groups, which are separate from the mainstream LDS Church, might still hold on to the doctrine.
So the historical context is definitely there, even if officially disavowed by the main church. How does this connect back to Menzies today legally?
Well, in terms of current Utah law, this history explains why the firing squad was even an option for Menzies. Our sources explain that inmates sentenced before May 2004, like him, actually had a choice.
A choice between lethal injection and firing squad.
Exactly.
Yeah.
For anyone sentenced after that 2004 cutoff, lethal injection became the default method, unless the state ran into issues getting the necessary drugs.
Mm-hmm.
Then the firing squad could become a backup.
Okay, so we've looked at the current legal fight over Ralph Menzies' competency, the does he know what's happening part, and we've dug into the unique history behind Utah's use of the firing squad, the why firing squad angle. Now, let's try to, weave these threads together.
Right, so we know from the sources that Menzies did choose the firing squad. It was his right under the law at the time he was sentenced.
And that's where it gets so incredibly complex, almost jarring. You have this method of state execution, the firing squad, with these deep historical roots tied to religious ideas about atonement through shedding blood ideas and now officially rejected, but still part of the history.
Mm-hmm.
And that's the method chosen by a man whose mental ability to even understand why he's being executed is the very thing being debated in court right now.
That intersection is definitely striking. But it's important to be clear about the legal question itself. From a purely legal standpoint, the competency hearing is focused on whether Menzies has that rational understanding of the legal reason for his execution.
Meaning, does he understand he was convicted of a capital crime and that's why he was sentenced to death?
Precisely. It's not legally about whether he understands the historical or, religious significance of the firing squad method itself.
So the sources don't really suggest his alleged dementia is being linked specifically to his understanding of the firing squad's history.
Mm-hmm.
It's just that's the method on the table because he chose it, and the core issue is his overall understanding of his situation.
Exactly that. The legal argument centers on his current mental state and whether it prevents him from grasping that fundamental connection. Crime leads to punishment. The specific history of the method, while fascinating and maybe unsettling, isn't the legal standard being applied in the competency hearing itself.
Okay, that clarifies the legal boundary there. So we've taken this deep dive, haven't we? We've peeled back the layers of Utah's quite unique history with capital punishment, looked at the complex origins of the firing squad within that history, and then focused in on this very current, very human, very difficult legal question. Is an individual whose mind is allegedly failing competent to face execution by that very method?
And the next big step, as our sources emphasize, is that judge's ruling. Judge-based decision on Menzies' competency expected, potentially soon after that November hearing concluded. That decision will really determine the immediate path forward.
So after going through all of this, what does it all mean for you, the listener? What's the takeaway?
Well, I think it really highlights how a state's specific, unique historical path, its laws, its cultural background, even its past religious ideas, can intersect in really complex ways with today's evolving legal and ethical standards, especially around something as profound as capital punishment and mental capacity.
It shows how the past isn't always past, right?
Exactly. It shows how echoes of history, even history that's been officially disavowed or moved on from, can still resonate and add these incredibly complicated layers to present-day legal battles over literally life and death.
It definitely leaves you thinking, doesn't it? Consider the weight of that history. You have a state practice, the firing squad, shaped by a unique past. And now that practice is tied to a case where the legal system is grappling with the most fundamental questions about consciousness, understanding, and the very justification for the state's ultimate act. How does that historical shadow fall across the determination of whether someone truly grasps their own fate? So something to really ponder.